Cohnlg unveils procedural steps to responding to trademark office actions. Receiving a trademark office action from the United States Patent and Trademark Office, USPTO, indicates that there are issues with your trademark application. Receiving a trademark office action from the United States Patent and Trademark Office, USPTO, indicates that there are issues with your trademark application that need to be addressed. Responding to these office actions promptly and effectively is crucial for moving your application forward. Here are the procedural steps to responding to trademark office actions. 1. Carefully review the office action. Read thoroughly. Carefully read the office action to understand the specific issues raised by the examining attorney. Trademark office actions can be either non-final or final, each requiring a different type of response. Identify issues. Identify whether the issues are substantive, e.g., likelihood of confusion, descriptiveness, or procedural, e.g., specimen deficiencies, classification errors. 2. Analyze the issues. Substantive issues. Determine the basis of any substantive refusals, such as likelihood of confusion with existing trademarks, descriptiveness, or genericness. Procedural issues. Identify any procedural deficiencies, such as incorrect identification of goods, services, specimen problems, or incomplete information. 3. Gather evidence and information. Collect evidence. Gather any evidence needed to support your arguments. This could include market research, consumer surveys, affidavits, and examples of use in commerce. Prepare documentation. Ensure you have all necessary documentation, such as revised specimens, amended descriptions of goods, services, and any other supporting materials. 4. Consult with a trademark attorney. Seek legal advice. Consider consulting a trademark attorney to help analyze the issues, develop a strategic response, and ensure all legal requirements are met. An attorney can provide valuable expertise and increase the likelihood of a successful outcome. 5. Draft your response. Address each issue. Prepare a detailed response that addresses each point raised in the office action. For substantive refusals, provide clear legal arguments and supporting evidence. For procedural issues, supply the required information or corrections. Use TEAS, Trademark Electronic Application System. Draft your response using the USPTO's TEAS, ensuring you follow the format and guidelines provided. 6. Submit the response. File electronically. Submit your response through the TEAS system. Ensure all necessary attachments, evidence, specimens, etc. are included. Verify submission. Double-check the submission to ensure all information is accurate and complete. Confirm receipt by the USPTO to avoid any delays. 7. Monitor the status. Track application progress. After submitting your response, regularly monitor the status of your application through the USPTO's Trademark Status and Document Retrieval (TSDR) system. Be prepared for further actions. If the examining attorney issues a further office action, e.g., a final office action, be prepared to respond accordingly, possibly with additional legal arguments or evidence. 8. Responding to a final office action. Request reconsideration. If you receive a final office action, you can request reconsideration by providing additional arguments or evidence to address the outstanding issues. Appeal to the TTAB. If the reconsideration request is denied, you may appeal the decision to the Trademark Trial and Appeal Board, TTAB. Tips for a successful response. Be timely. Submit your response within the specified deadline, usually 6 months from the date of the office action. Missing the deadline can result in the abandonment of your application. Be clear and concise. Make your arguments clear and concise. Provide a logical and well-structured response to each issue raised. Provide strong evidence. Use strong, relevant evidence to support your arguments. This can significantly enhance the persuasiveness of your response. Maintain professionalism. Keep your response professional and respectful, even if you disagree with the examining attorney's findings. Conclusion. Responding to a trademark office action involves a series of procedural steps that require careful attention to detail and a clear understanding of trademark law. By thoroughly reviewing the office action, gathering appropriate evidence, and crafting a well-structured response, you can effectively address the issues raised by the USPTO. Consulting with a trademark attorney can provide valuable guidance and increase your chances of overcoming the objections, ultimately helping you secure your trademark registration.